Hi everybody, my name is Silvio Vinceti. I recently got my PhD degree from the University of Modena and Reggio Emilia in constitutional law. I want to first of all to thank Laura Kayalane and Ronan Kennedy for the very generous invitation. I'm very happy to be here, even though in an online modality. The topic that I'm going to address today is basically a comparison between the Irish and Italian system for judicial discipline. I call it How Not to Try a Judge because, maybe differently from other perspectives, I tried as much as possible to keep the focus on the judge. So in the second part, I'm going to address some policy questions, and generally speaking, I tried to frame them from the perspective of the judge. Often, judicial discipline is seen as a safeguard, a guarantee only for the public system to rely on the judicial system, to have a good judicial system in health. But actually, I think it is first of all for the judiciary itself. There is a strong interest of several judges to be a judge and treated fairly in disciplinary proceedings. So first of all, I laid out some problems from the comparison for a comparative perspective on Ireland and Italy's system for judicial discipline. We're still talking about a country of 60 million people and a country of 5 million people. We are talking of a country who currently employs more than 10,000 judges, and a country that, for what I understood, employs some 170 judges. So Italy is by far more complicated to administrate from a legal perspective. There is way more contentious issue, and that reflects in the people to judge ratio. It is hard to compare the two systems because their roots they branch out of two different traditions, one of civil law and one of common law. But you can also find difficulty in comparing the two systems because the standard of words like scandal is very different. The two systems can be seen in a little bit of a turmoil because of the Gulf Gate in Ireland, and because of the Palomar Gate concerning a judge who was at the head of a system of cooptation of position within the judicial body, within the judiciary. So whereas the Gulf Gate pertains an unethical and improper conduct, but does not. It seems that it does not consist of any kind of offense or illegal behavior. So it is also a matter of different standard of I think that from a medical perspective, you would say that the Irish system is way more healthy than the Italian system in regard to the judiciary and also judicial discipline. At the same time, despite maybe some differences, there is I think an important rationale for the comparison, because judicial discipline involves very theoretical questions and issues like how much to submit the judicial power to the legislative body, and how much to grant independence, how much to safeguard the prestige of the judicial body with secrecy, and how prevailing must the transparency of the system be. How can you better foster public trust toward the judiciary, with transparency or with secrecy? So all these issues are very theoretical, and I think really make it possible to compare the two systems. Another interesting fact that bodes well for the comparison is that in the most important document that has been released on the ongoing debate for the reform of judicial self-government in Italy, Ireland is actually the only foreign country that is mentioned, and that is because of the single transferable vote that the Luciani Commission that was established by eminent constitutional scholar and head of the constitutional and former head of the Constitutional Court, Marta Cartabia. She established this commission for the reform of the judicial system, and in particular with regard to the reform of judicial discipline and self-government of the magistracy. And Ireland is thanks to the archetypal model of single transferable vote, Ireland is here quoted. So a general outline of the Italian system of judicial discipline. They find themselves liable on several grounds, on ethical grounds if they violate the private code of conduct of the National Association of Magistrates, which has its own code of ethics, but it is a private association. They can be liable on professional grounds if they bring about conduct that is a sign of unprofessionality, and so they can be evaluated poorly in the periodical evaluation. But the most important responsibility is certainly the discipline responsibility, the civil responsibility, and criminal responsibilities. These last two categories can be maybe we can move on in this respect. So, in a nutshell, how does judicial discipline actually take place? If a party in a proceeding or another judge sees a judicial misconduct on the part of a judge, meaning a conduct that breaches one of the several norms of judicial conduct that are laid out in the law, in one of the law that of the previous slide, the judge or the party, the private citizen, will signal that to the superior council of the magistracy, although the person, the office who is in charge of evaluating at the first level the complaint is the General Prosecutor office at the Court of Cassation in Rome. The Minister of Justice has some powers in respect to investigation, but the General Prosecutor is by far the most important figure in the predisciplinary proceeding, because the General Prosecutor office is going to evaluate whether the allegation of judicial misconducts are sound, or at least are as credible as to be submitted to the discipline committee. The discipline committee is actually the main protagonist, is the central phase, the central stage of the discipline process. The discipline committee is one of the several committees of the Superior Council of the Magistracy, and it is the place where the process for judicial discipline takes place. Against the decision of the discipline committee, the judge can appeal before the Court of Cassation, which is going to decide in a grand chamber fashion. But clearly, the most important phases, in most cases, the single allegation is decided at the first or the second level of this pyramid. Skipping now maybe on some critical and very important elements, but that can we take back in the policy section. In this slide, you can see some some of the differences between the two models, I find very important to emphasize how the fact that removal from office is a parliamentary power in Ireland, whereas in Italian judicial system, in the Italian system of judicial discipline, it is judiciary power. And that, as everybody can understand, this is a very momentous difference between the two systems. Certainly, it is interesting to see that Ireland does not know of automatic removal or sanctions in some case of judicial misconduct, whereas the Italian system does have those kind of mechanism of automatic adoption of some sanctions for some misbehavior. So the discipline judge cannot decide, cannot graduate or choose among a degree of sanction. It has to adopt that kind of sanction. The Italian system does not have in any way form of resolution of judicial misconduct cases by informal means, differently from the Irish model. On paper, in the so-called law on the books, I would say that publicity of judicial discipline in Italy and Ireland is very similar, in the sense that both systems expect the proceeding to be public, but they also lay out some clauses that, in the case of Ireland, is the safeguard of the administration of justice. In the case of Italy, is the credibility of judicial function, or some party privacy rights. On these grounds, the judicial discipline proceedings can be secret, are not public, so there is a room for secrecy, let's say. And speaking of policy debate, I wanted to outline three main issues that I think are very important. The first policy issue is the relationship between transparency, case law, and justice. One of the main shortcomings, I think, of the Italian system, and I'm not alone in thinking this, as we will see, other scholars more eminent and more important than me has pointed this out for a long time. One of probably the single most important problem is the fact that the General Prosecutor in the Court of Cassation in Rome has a tendency to close and to dismiss beforehand several proceedings, and the problem is that this predisciplinary decision not to pursue, not to send the case to disciplinary section, to the disciplinary committee in the Supreme Council of the Magistracy, is not actually motivated. So neither the compliant, neither the party, the private citizen that witnessed judicial misconduct, nor the judge concerned are made aware of the fact or why the general prosecutor decided not to bring the case before the disciplinary committee. In this slide, you can see Rosario Russo, who is one of the he's a former prosecutor who is outlining the very thing that I mentioned about general prosecutor dismissing too many and without any kind of ration, but without any kind of motivation, too many judicial discipline proceedings. And also Professor Daniela Cavallini has outlined this critical aspect. Another policy problem is the procedural confusion. In Italy, for example, there is a procedure for transferring judges, and sometimes it is used to obviate to in place of the discipline procedure. So if you have a problem with a judge, you abuse the system in a way and transfer it to another place. But this is very problematic also for the judge, because in the case of judicial transference, you don't have case law, so you cannot know whether the judge is being treated alike as in other cases. So that is a huge issue. There is an overarching theme that is about the legislative participation in judicial discipline. Of course, when you see a system like Ireland, who allows for judicial impeachment by the legislative, you do understand that the separation of power, you can touch the fact that the separation of power does allow for stronger intervention of the legislative in judicial discipline proceedings. And I personally favor some kind of last resort mechanism to address judicial misconduct. So I don't like the idea of parliamentaries or MPs taking part to judicial misconduct proceedings. But I think there can be a last resort emergency mechanism to control the judiciary. So in case like the Palomar Gate, you have to have an instrument, a tool like the judicial impeachment power in Ireland. One critical aspect of the Irish system that is still unclear to me is the public appointment service, because it seems to me that in the Judicial Act there is a strong power of the public appointment service, in the sense that the government can either accept or deny. It seems to me that the government can either accept or deny the names, the proposal of lay members. That is, of course, okay if the public appointment service is actually trustworthy. It is a governmental independent institution. Otherwise, there can be some separation of power issues, I think. And this is the last and most difficult part, because my Irish is too bad to use it. It's definitely too bad, although of several YouTube. I just want to thank you very much for the attention, and I hope that this presentation was interesting. Thanks again.